Hello?
Hi, I'm sorry. This is the first time I've used Zoom before.
That's okay. I want you to log on early for that reason. This is Andy.
It is.
Okay. I'm going to put that next to your name on the court. Your judge will not be on until 12:45. So he'll hear you. He usually does arraignments right at the top of the schedule. So should be between 12:45 and 1 o'clock. So just stay on, but I'll bring you back into the meeting when he's ready to hear your case. Okay?
Okay, perfect.
All right.
All right, thank you.
You bet. Is he- Just waiting on John.
Hey, Lisa,
Yes,
is Chris, what's going on with, are we doing Rogerson today or not?
we are not today. We're rescheduled for the 16th.
Oh, okay.
That explains my message to you.
Oh, I see. It's gonna-
Sorry.
It's likely be resolved that day.
We don't know. I'm not sure.
That's fine.
Okay, the intent is, yes,
So I bring that up because the only other thing Mr. Bates is waiting on is the Meyer case.
yes. And Mr. Meyer's here. We're just waiting on John.
Okay. I mean, I pretty much could tell before what's going on, but if we want to wait a few minutes, that's fine too.
That's up to you guys. I'll do whatever you want to do.
It's up to Chris.
Well, last time Mr. Myers was here and then Mr. Quinton came in and we had to reiterate everything, so why don't we wait a few minutes to see if Jonathan will come in.
Sure. I'll send him an email right now too.
I just did too, and Jamie's on, his assistant, so I'm sure she's communicating with him as well.
All right. Thank you.
Yep. There he is.
Mr. Quintner, you've decided to join us.
I'm sorry for my antics, Your Honor. Sorry, I was thinking 12:45. Are we doing the interpreter?
We're doing Richard Meyer.
Okay.
I'll bring him in now.
Hello?
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 Hello, Mr. Meyer. This is Judge Chris Bates, and we just brought you into the South Bend Municipal Court. Can you hear us?
Yes, I can. Thank you.
Okay, your attorney is present, as is the city attorney. And
Okay.
the matter comes on for pretrial. Gentlemen, how are we proceeding?
Well, Your Honor, Mr. Penoyer asked me today where we were at, and I let him know that I have sent a subpoena ducis tecum to Valley View, where Mr. Meyer was attempting to be treated. I'm sorry, I don't know if Your Honor is all caught up. This is a sentence compliance matter. He's trying to fulfill the terms of his judgment and sentence on a DUI from some time ago. And what's happening here is we're having a hard time getting Mr. Meyer services because he is a medical marijuana user with a card, not that you need it anymore. And we just cannot get him seen by a facility that won't discharge him based on that. I just got a new email from him today saying that Willapa had informed him of the same, although it was a little unclear whether that means they'll discharge him. They will consider him to be out of compliance. We have shown them an order that's from the court saying that we, the court, will not consider him out of compliance. What I don't know is whether they're refusing to accept him into the program or whether they would just report him as non-compliant. Mr.
They're refusing me in the program.
What's that?
They're refusing me to the program.
Okay. Okay.
Even with a court order, they're refusing.
Yes.
So this is new information as of today, and so apparently we're going to have to reach out and try to find a program that won't discharge him based on that. Seems strange, being that marijuana is recognized as having medicinal use.
What is left to do as far as treatment?
All the recommendations be assessed.
Well, I've been assessed and I've done 40 hours. There's 75 hours required in the state. Yeah, I'm over halfway there, but there's nobody I can get services from to complete the other 30.
The first half was from Valley View?
The first half was done, the 39 hours was done. I had an assessment done and I did 39 hours at Lifeline in Aberdeen, and then they suspended the bus service. So I don't even have any way to get up there any longer. I thought I would get my driver's license replaced. I've met the state requirements, but I've yet to meet my personal requirements on that one. Driver's license would have allowed me to travel to Aberdeen, but I've yet to meet my personal requirements, and it's doubtful I will.
So it seems like the short answer, Your Honor, is he's got about 35 hours left to do.
My thought on this is, I guess, because we have a lot of variables here, I'd like to see Mr. Meyer's treatment records and see what he has accomplished thus far and see what that translates to, because it may be that the remaining 30 hours are not necessarily entirely meaningful. I don't know. I'm not saying they aren't, but I think it'd be worth looking at because of the fact that we keep coming back on this case.
Okay.
I think that's a good idea, especially if defense counsel wanted to make a motion to release Mr. Myers from any further treatment requirements in order to evaluate a potential motion like that, the court would like to see what has been accomplished thus far.
Okay, well, I'm checking my records to see if I've got that already from Lifeline. I don't. I'll double check with Mr. Meyer that I have a HIPAA release that's still good.
There's a release. I'm sorry. There's a release been signed for both the court and my attorney at Lifeline. It was signed in March, maybe April of 19 or top 20.
Okay, I just want to make sure that it's not past the expiration date.
Yeah, they may have expired. There may need to be a new one. Normally those are good for about 90 days and then the treatment for.
Oh, okay.
So
you and I will talk about that, Rick, by
The
email.
court has received the assessment on January 9, 2020, and a treatment plan on January 16, 2020, but that is all the court has received.
Okay, I'll get in touch with Lifeline.
Can we reset this maybe for January 6th?
sure, and what I will say, Mr. Quintner, if you're able to obtain all records, up to the point of discharge or release, and wanted to make a simple motion to have the court consider evaluating what's been done and potentially releasing Mr. Meyer from further conditions, I'd be happy to consider it at that time. What I don't know is how that would have any potential effect upon DOL and licensing.
I think I've already. I'm sorry. Am I interrupting?
Go ahead.
I got a letter from the DOL that says I meet all requirements as of March of 2020. So according to DOL, I could go get my license.
Okay.
The way I understand it. Yeah. I personally have some issues that I can't.
Okay. Well, I think that the judge is just making sure you guys were thinking about that variable here. So if nobody objects, Judge, does that sound okay to you? We could set this over a month to January 6th for review.
If that question's being asked of the court, there's no issue setting it over to January.
That was asked. Sorry if I wasn't clear.
Yeah, no objection. That sounds fine.
Okay, Mr. Myers, we're going to give you some time, you and your attorney, to try to gather up all records and present them to the court. I'm not trying to force your attorney to do anything, but what I am saying is the court would be willing to consider potentially releasing you from your obligations based on what's provided, but I can't make any guarantees until I'm able to review that and get the city's opinion.
Okay, I understand.
Okay, I think that concludes your case, Mr. Meyer. You can log off.
Thank you, Your Honor. Thank you, John. Have a good day.
No problem. Take care, Rick.
Okay. I think that completes all my docketed cases.
It does.
Thank you, Judge.
Yes, Your Honor, and sorry for making you wait.
Okay, let's not make it a common problem, Mr. Quinton.
Certainly.
All right, thank you.
Okay. We're supposed to have Mr. Nunez on at 12:45. I don't see him or Pete.
Okay.
Let me email Pete.
What I have to contribute is that's what was holding me up. Attempted communications with Mr. Nunez, but I know that he is present and he is planning to attend today. Pete told me that to let the court know that we're in no particular hurry to get his
Okay.
obligation done with. His 1 o'clock is
Okay.
canceled.
Thank you, because that was my note. We had to hear him at 12:45.
Yeah.
I just sent him another email with the info, so hopefully he can get logged on real quick.
Okay.
But again, I don't have Mr. Nunez. I've not heard from him. He usually stops and picks his information up, his logon information. And I haven't seen him yet, so I'm not sure what to make out of that.
Well, I had a couple people ask me today if the login information is the same.
I'm sorry, can you repeat that?
Yeah, I had a couple people ask me today if the login information is the same as it's been.
No, it's
Yeah,
a different
I
one for
actually
each
forgot that and
case.
I told Ms. Rios that it was. Actually, let me,
I had emailed her hers on Monday, so, and she did catch it. She is logged on, so she
Oh,
did
good,
get
okay.
that email. Melissa Walters, another one. I'm not sure if she got hers. Everybody else that I was afraid of has checked in or logged on, so.
So
Well,
are we still waiting on Mr. Hinton?
We are, do you want to do,
I'd like to move it along,
Okay.
if you could. I think the mitigation makes sense, and then we can bring Killian in for everything else, you know?
okay. I don't see him. There is a number I don't recognize, so I'll bring him in and see who that is.
Hello.
Hello, who are we talking to?
Hi, my name is Matthew Peck.
Okay, Matthew, we're going to hear your case in just a little bit, okay? Hang on with us and we'll bring you back in just a little bit.
Okay, I'll be here.
All right, thank you.
Thank you.
Okay. Other than that, we can either start on stuff with Mr. Duncanson, or we could start on the arraignment. I don't find either way.
I have both the arraignments are here.
Okay. Okay, I guess, why don't we start with that then?
Okay, I'll bring in Chuck Coma, Charles Coma.
Mr. Coma, can you hear me? I can see Mr. Coma, but I do not hear him. And I don't know if he can hear me.
I messaged him to let him know to check his microphone and speaker.
Okay. Mr. Coma, can you hear me? Can you hear my voice? Okay, he doesn't seem to be making any end. Yeah, I get it. It's in here.
We'll put him back in the waiting room and hear Andy first, and then,
That's fine. Whatever's good. Whatever. we
okay, I'm gonna let him know.
Yeah,
Oh, there he is.
I couldn't hear. The something was wrong.
Mr. Coma, can you hear me?
Yes, I can hear you now, but I couldn't hear you before because I didn't know how to work this.
Okay, well, great. I'm glad you can hear me now. Mr. Coma, my name is Will Knoyer, and I am the judge for the city of South Bend. And I have you on here today for an arraignment, which is like first appearance on a charge of hit and run unattended vehicle. Basically, this is arraignment. So at this point, I'd advise you not to make any statements because statements could be used against you. I'm just going to go through your rights with you and then ask you if you would like to have an attorney appointed or hire an attorney, and we'll go from there, okay?
Yes, Your Honor.
Okay, great. So you were charged with hit and run on an unattended vehicle. That is a gross misdemeanor, which means the maximum penalty is a $5,000 fine or 364 days in jail. That's not what you're likely to get, but that is what the maximum could be. You have the following rights. You have the right to remain silent. That means you don't have to say anything about the case. You have the right to be defended by a lawyer and have a lawyer present at hearings. If you cannot afford an attorney, one will be appointed for you by the court. You have the right to have your guilt decided by a jury and to be presumed innocent until proven guilty by a jury. You have the right to be present when any evidence is being presented in your case. You can call witnesses to testify for you, and you can have witnesses testify at no cost to you. You have the right to a speedy trial within 90 days of the date that you enter a not guilty plea. If you plead guilty, you give up all these rights. If you plead not guilty, you retain all of these rights. As I said, you're charged with hit and run unattended vehicle. I've reviewed the police reports, and I think there's enough there to go forward with the case. I find probable cause. That does not mean that I'm finding you guilty. It just means there's enough in the reports for the case to move forward. Do you understand what you're charged with and what the maximum penalty is?
Yeah, I don't really know. I do have a question for you though.
Okay.
Can I plead to, is there such thing as a deferred?
Well, that's something that you would need to talk to your attorney about. It certainly is a possibility in your case, but it's not something I can just discuss directly with you. Okay?
I don't even have an attorney. Can
Well,
I get
Mr. Coma, I'm getting to that. Just give me a second here. So, Mr. Coma, would you like the court to appoint an attorney for you?
That'd be great.
Okay. Can you? I'm going to assume I have to make sure you qualify financially. Do you know what you make a month?
I like 1,500, I think.
Okay. Well, then you do qualify. So I'll appoint Mr. Quittner. At this point, if you have no objection, I'll enter a not guilty plea for you, and you can talk to your attorney about working out a deal on this case or whatever it is you want to do. Does that sound good?
Yes, Mr. Penoyer.
And I do have to ask, Mr. Coma, were you the Mr. Coma that used to live at the bottom of my hill when I was growing up?
What's that?
Did you used to live in South Bend on First Street?
Yes, are you Joe Penoyer's son?
I am, Mr. Coma. I was curious if that was you.
Whoa, that's why I was saying something earlier, but I didn't want to get in the way of the proceedings.
Well, I appreciate that. I just was curious if it was you. It's nice to see you again.
Hey, it's nice to see you too. What time does to us? Hey.
Yes, it certainly is. It can be merciless to us. Yes. So, Mr. Coma, what I'm going to do is we'll give you the information for Mr. Quittner, the public defender, on your case, and you can talk to him about working something out. And what's our next court date, court administrator?
12/16.
Okay, so we'll be back on here December 16th at the same time, Mr. Coma.
December 16th?
Yes, sir.
Okay, that's great. Hey,
Okay.
I appreciate your time and patience with me. You know, I got a little traumatic brain injury, but could you tell your mom and dad hi from me?
I'll be happy to do that, Mr. Coma. It's nice to see you, and I will see you again in 2 weeks, okay?
What time?
Okay, what time will that be?
Well, it'll be the same as this. You'll have to log in to the thing at 12:45, okay?
You'll get a new notice.
You'll get a notice in the mail that tells you what to do.
Okay.
Okay.
Okay, well, hey, it's good to see you.
Good. Good to see you too, Mr. Coma. Have a great day.
Small world.
Small world, yes.
Bye.
See you later.
Okay, now we have Mr. Preisenberger.
Weinesberger, rather. I know it's family,
Weinesberger.
so I know the name, yeah. I know everybody, it seems. Mr. Weinesberger,
Yes, sir.
you can hear me okay?
I can.
Great. This is Will Penoyer. I'm the judge for the city of South Bend. And you're here today for your first appearance on a case. What I'm going to do today is just go through your rights and then give you a chance to see if you need to get an attorney appointed for you. And we'll go from there, okay?
Okay.
All right. So you know, it's pretty much the standard spiel you probably heard if you've been in court or ever watched a court show. You have the right to remain silent. You don't have to say anything about the offense today or in the future. You have the right to be defended by a lawyer, have the lawyer present at all hearings. You have the right to have your guilt decided by a jury and to be presumed innocent until proven guilty at a jury trial. You have a right to be present when evidence is presented to the jury and question witnesses. You can call witnesses to testify for you at no expense to you. You have the right to a speedy trial within 90 days of the day you enter a not guilty plea, which would probably be today. Obviously, if you plead guilty, you waive most of these rights. You are charged with, it looks like the only criminal charge is failure to transfer title within 45 days. It's probably one of the least serious criminal charges we ever see. And then you have a couple of infractions for failure to renew tabs and operating vehicle without insurance. So only one of those is criminal, and the maximum penalty on that is 90 days in jail or $1,000 fine. That's the maximum, not what you're probably going to actually get, okay?
Okay.
So I've reviewed the police report, and I find that there is probable cause, which just means that there's enough facts in the report for the case to go forward. It does not mean that I found you guilty yet, or that I will find you guilty at all. Do you understand what you're charged with and what the maximum penalty is?
Yes, sir.
Okay, great. Mr. Preinesberger, would you want to have an attorney appointed for you, or are you going to hire an attorney?
I really don't think so. I mean, I hate to say it. I made a really dumb, stupid mistake. I don't really.
I'd advise you to remain silent for now, if you would, on that, just because I'm the judge.
Okay.
Do you want to talk to an attorney and see what kind of deal you could work out with the city, maybe? Well, let me ask you this. What is your monthly income?
Right now, it's very little. With everything going on with COVID, business has been very, very slow.
Yeah, you run a mechanic shop, correct?
Correct.
Yeah, so I imagine that's tight right now. Well, so do you think you bring in less than $1,500 a month personally?
No, I probably bring in a little bit more than that.
All right. Well, at this time, I'm gonna just see. I think it'd be better. I'd like to appoint an attorney for you. It doesn't sound like you can afford to hire your own attorney right now. So what I'll do is I'll appoint you an attorney. You can talk to the attorney. What will happen is you'll talk to him. He'll talk to the prosecutor, and there'll be an offer on the table, probably to resolve the case. You can take that, try to get a different offer, or you can just say, to heck with it, I deny everything. I'm just telling you what your options are. So
Sure.
What's going to happen is I'll schedule you for the next court date, which is December 16th. And between now and then, you'll get information on how to contact your public defender, Mr. John Quitner, and talk to him and see if you guys can work something out. Okay.
All right. I appreciate it.
Okay. Let's just confirm your address and we'll let you go. What address do you get mail at?
728 Barnhart Street, Raymond, Washington, 98577.
Does that look right to you, court administrator?
Yes, that is where we sent the last notice.
I'm not saying it isn't right. I just want to make sure we're matching up here. Okay, in that case,
Sure.
Mr. Preinesberger, just watch your mail and talk to your attorney, okay? We'll see you on the 16th.
All right. All right. Thank you.
Bye-bye.
Bye.
Okay, Pete's here, but I'm still not seeing Mr. Nunes.
Okay. I'm just printing off, I just got some paperwork on the pet case in my.
Yeah, I
email.
forwarded you. I did not read it, but I forwarded it right
Oh.
to you.
That's fine. I'm just printing it off so I have it available.
Okay, so we've got Benita Rios and Matthew Peck, both available.
Okay, well, Peck, I'm still getting that paperwork printed off here, so why don't we?
Okay,
let's
do Benita.
Okay. Hello, Miss Rios.
Hello.
Will Penoyer again, judge on this case. Mr. Quitner, Mr. Duncanson, want to let me know where we are on the case?
Yeah, we have a resolution worked out. I've sent the appropriate pleadings to Ms. Rios, and last I heard earlier today, she was on her way to her mailbox to see if they had arrived. And I don't know whether they did.
Yeah, I got him.
Okay,
So it sounds like we should probably set it out so that she's had a chance to go over them, and I could advise her of her rights.
that makes sense to me too. So Ms. Rios, we're just going to continue this one more time so that you can go over the documents with your attorney.
Okay.
Mr. Duncanson, I assume you're fine with that?
Yep, not a problem.
We don't have any speedy trial issues here.
Shouldn't.
I don't believe so.
Rain, it was 11/4.
And we're good. That was less than a month.
We have to have trial by February 4th. Yeah, we should be fine then. Okay, so we'll do this again on 12/16. Ms. Rios, thanks for checking in.
Okay. Thank
I
you.
appreciate it, and we'll see you in 2 weeks.
All right. Thank you. Bye.
Bye.
Are we ready with Mr. Peck?
Well, I thought Mr. Duncanson sent me stuff on PAC, and then you sent me something on PAC. Are they different documents, or are they the same thing? Or?
I forwarded you what John sent me. Like I said, I didn't read it.
I signed it and then forwarded it back to John, Lisa, and I added you to the email as well.
Okay, the ones I have look like they have everybody's signature on it but mine.
Awesome.
So, that being the case, then I guess I don't see any reason why we can't handle Mr. Peck's case at this point.
Okay.
Mr. Peck, are you on there?
Yes, I'm here.
Okay, great. Let me know if you can't hear me or anything, okay?
Okay.
All right, again, Will Penoyer, judge. I've got a statement of defendant of pleading guilty and a judgment and sentence here. So my understanding, that looks like you're pleading guilty today. You've worked out a deal with the state, or the city rather.
Yes, sir.
Okay. In that case, you just have to be patient while I go through this document with you, okay?
Okay, I'm listening.
All right, appreciate it. How much school did you finish? I have to write it in here.
How much what did?
How much school did you finish? Like, did you graduate high school? I have to put it on this paper.
Oh, okay. I almost got my associates, so about 13 years, I guess.
Okay. I'll just say 12 plus.
Okay.
So it appears you were charged with disorderly conduct fighting, and you're pleading to that with a $250 fine. Does that sound right to you?
Yes, sir.
Okay. And as you understand, I have to go through all the rights now. By signing this, you give up the right to a speedy and public trial by an impartial jury in the city where the crime is alleged to have been committed, the right to remain silent, the right at trial to question and hear witnesses against you, the right to testify and have witnesses testify for you at no expense to you. You lose the presumption of innocence until you've been proven guilty, and the right to appeal a finding of guilt after trial. Your appeal rights are very limited here. Really, the only thing you could appeal is if I gave you a penalty far outside the scope of what would normally be given on this case. That's very unlikely to happen. I assume the attorneys have worked out a reasonable deal here. the crime which you're charged with, the maximum I could give you is 90 days in jail and $1,000 fine. The recommendation is just 90 days all suspended and $1,000 fine with $750 suspended. Which, what this means as a practical matter is there's no probation officer. You got to pay $250 within 12 months and not have any criminal violations of law. Provided you.
I understand. I was wondering if there's any way I could do community service.
I don't have a problem with that. You'll just need to coordinate that with the city, with the court administrator, Lisa. You need to have a place where you're doing it that's an official, nonprofit of some kind. And you need to have someone there who can, oversee you to some degree and, document your time. Does that make sense?
Yes, sir, it does.
What are we doing hourly now, Lisa?
$10 an hour.
$10 an hour? I thought it went up for some reason, but maybe I was a different court. I don't remember. Okay, so $10 an hour, so 25 hours or, some combination of hours and money, okay?
Okay, that sounds very reasonable.
All right, so I just got to finish going through this with you. This is still the plea document. I don't have to follow anyone's recommendation. I can give you up to the maximum. If you're not a citizen of the United States, a plea of guilty could be grounds for deportation, exclusion from admission to the United States, or denial of naturalization. None of these other things in here seem to apply to you. Just let me get to the end. So at this time, what is your plea to the charge of disorderly conduct / fighting?
Guilty, sir.
And you make that plea freely and voluntarily? No one's threatened harm of any kind to you or any person to cause you to make the plea?
Yes, correct.
No one's made any promises to you to enter this plea other than what we talked about earlier?
Correct.
Okay. And it says in your own words, on or about July 6, 2020, I did engage in a verbal fight with my girlfriend in public, disrupting the peace of others while in the city of South Bend, Washington. And you've discussed all this with your attorney?
Yes, I did.
Okay. I'm going to find that this plea was made freely and voluntarily, that you know what you're doing here, there was no coercion, and I'm going to find you guilty. All right, I assume we're going to do sentencing today as well. As you already know, the deal is I'm going to agree to what the lawyer said. So it's just going to be 12 months probation, $250 fine. You're free to do community service if you wish. No criminal violations of law. And do we have any no contact provisions here, or is there an agreement on that? Or
Yes, there was one with my wife or girlfriend, as you guys say. Danielle Northrup. I'd like to have it dropped, please. I need to be able to talk to her.
Okay. Well, Mr. Dunkerson, what's your position on that? I don't see it in the JS, but
I think the order was on her, right?
No, it would have been an order on him because it was only a pretrial no contact order.
I don't see anything in JABS that's saying there's a.
Yeah, I don't know of anything.
To the extent there is an order, I wouldn't have an issue of it dropping.
Okay, so Mr. Dunkerson, to be clear, you're not asking for any kind of no contact order.
No.
If there's one and no one seems to see one in place, so it sounds like there's really nothing for me to do here on that point.
I just saw her name on my paperwork as not to talk to her in regards to this charge. So
Okay.
That's why I was asking.
No, I appreciate that. You should ask. You don't want to make any missteps, right?
Yeah, I don't want to get in trouble for something that's, an oversight.
Absolutely not. I don't want you to get in trouble for oversights either, sir. I'm not aware of anything. The clerk says there's nothing in the file, so I'm going to have to take that as a record that there isn't anything. If it was just a pretrial release condition, it would be invalid anyway now because you pled guilty and you didn't enter a sentence, okay?
Okay.
All
Sounds
right.
good.
I'm going to sign the judgment and sentence and the statement of defendant on plea. And I think we're done if everybody else is satisfied.
Nothing else.
All right.
Okay, just make arrangements with the city clerk to make payments or do the you know what I'm talking about, to do the community service.
A community service?
Yes. Okay.
Gotcha.
Thank you, Mr. Peck.
Thank you, sir. Have a good day.
You too.
Bye-bye.
Okay, I have a number I don't recognize. I'm gonna bring them in and hope it's Mr. Nunez.
Hi, this is Melissa Walther.
Okay, we'll bring you right back in just a second, okay? So I'm gonna bring Pete in. He has to go on record.
Okay.
And we lost him. While we're waiting for Pete to come back on, I'll bring this number in and see if we can figure out, oh, that was Melissa, wasn't it?
Yes.
Okay, I'm losing my head here.
Is that the only other one we have?
That's the only other one that's there, yeah.
Okay, so the mitigation. Is not on.
Yeah, he's not.
Okay. Well, then we just have Walter and Mr. Nunez.
There he is. There we go.
Okay, there we are, Lisa. Sorry about that. I accidentally hit the wrong button and knocked myself out again.
Hi, Mr. Hinton, Will Benoyer here, Judge, City of South Bend. You hear me okay?
Everything's doing very well, Judge. I even remembered to dress properly for court today.
Well, once in a while it happens. So we have you on today for Nunez case, Mr. Ivan Nunez, and we don't have him on the phone right now.
Yeah.
So I don't know that there's really much we can do today, but unless you've had some sort of contact with him we're unaware of.
Did I tell Mr. Nunez that the login information is the same as last week? Did I tell him that?
I
can't remember. Yeah, Your Honor, I can just tell you that I was on the phone with Mr. Nunez and Mr. Quintner here about 30 minutes ago. We had a conversation about his case. And I asked him if he knew he had court today, or actually counsel did, and his response was yes. And I said, we'll see you in court. And he said, okay. So I'm a little surprised.
Well, given the nature of the situation, I'm not going to issue a warrant, but I will say involuntary non-appearance if he doesn't show up today, simply so we can keep the case moving. But so I guess since he's not on, I guess we'll have to let you go, Mr. Hinton. Are you around for the next half an hour if he happens to show up?
Yeah, I sure am, Judge. I've got my next commitment with DOL isn't until 2 o'clock, so we got plenty of time. So what I'll do is I'll log off the meeting, but I'll keep my phone and headset on, and if you folks need me, just give me a quick call and I can either log back in or we can do it by phone.
Okay, thank you so much, Mr. Hinton. We really appreciate your courtesy.
My pleasure. We'll see you folks in a little while.
Okay, we'll bring Miss Walther in. Hello.
Hello.
Hello, Miss Walther. Can you hear me okay?
Yes.
Okay, this is Will Benoyer. I'm the judge for the City of South Bend. And your case is on for a pretrial today. I'm now going to ask your attorney where we are on the case.
Your Honor, I don't know. I haven't had any contact with Ms. Walther.
Okay. Ms. Walther, do you have his contact information, Mr. Quitner's?
I do not.
Okay. Well, we'll give you his number right now, okay?
Okay.
Pen?
Yes, I do.
Okay, great. His name is John Quitner, Q-U-I-T-T-N-E-R. And his number is 360
Okay.
642
Okay.
3139.
Okay. 3129.
39.
3139.
You got it.
Okay.
So
Got it.
what I'm going to do then, since we're not prepared to go forward today, unless someone has an objection, I think we should just set this to our next court date, which is December 16th. And so that Mr. Quittner has an opportunity to talk with Miss Walter. Is that all right with everybody?
Yes, thank you.
Sounds good. Okay.
Okay.
Yes.
Great. Just one question for the clerk. Do we have any speedy trial issues on this case?
Arraignment was 10-7. We had a bench warrant.
If we had a
Yes.
warrant and she came in on that, then I'm not
Yep.
worried about it. Okay.
10-21. So
Okay. So in that case, that works for me. We'll be back here December 16th. Ms. Walter, please call your attorney and talk to him before court, and you'll log in the same way you did this time. Okay. There may be a
Okay,
different login
thank
number,
you.
but it's the same process.
Okay. Okay.
Okay. Do you have any questions?
Nope, that's all.
Okay, great. Thanks so much. You can go ahead and you can hang up now.
Thank you.
Okay.
we have nobody in the waiting room. So
All right. So if either of the attorneys have anything to present or discuss.
I believe so, Your Honor.
Okay. All right. You guys can go ahead and log off. I'm going to deal with the last case that's on. It's just a mitigation.
are we gonna reset, Mr. Nunes?
Oh, I'm sorry.
That's okay.
Yeah, I guess for the 16th. I don't know what else to do.
We need to not do that. That's
No?
the one I sent you.
Oh, right. That's right. Okay, well, since it's a voluntary non-appearance, I'm not worried about time anyway. So let's do it on January 6th.
Okay.
Okay.
Okay, thank you.
All right. Thanks, guys.
So I actually had a question
Oh,
about the trials in January.
Okay.
More specifically, the pro se one, which I know that's technically Chris is going to be hearing that, but I believe our trial readiness is the 16th. So I'm just wondering, what is the chances of us having trial in January?
Chris said he has time to hear both cases on the 16th, both the Rogerson and Taylor case. That's as much as I know, is that we will have time to hear them both.
it's not Rogerson, right? It's Odom.
Oh, sorry, Taylor.
It's Taylor.
Taylor
Taylor's
and
the one going to
Rogerson.
trial.
Taylor and
Right.
Rogerson are both on for the 16th for Chris
Correct, but the trials are Taylor
and
which is
Odom,
Chris, and then Odom, which is me, right?
right?
And
Yeah.
that is-
But we have a
Which day again?
timing issue with Chris on the 16th. So that's, I'm trying to make sure that we don't have too many hearings scheduled on that day because we already have a time crunch.
that's fine. So what date is the trial again? January what?
19.
And we don't even know where we're gonna hold it at though, right?
We do not have a venue at this point. The chamber is not taking any rentals or accepting any rentals right now. We don't have another venue, so it could change between now and then, but
Okay.
I don't know. Our thought was to schedule both the trials on the same day. That way people only have to come to town here once. We have one jury pool. Try to keep everybody as separated as possible, but done in one day.
Okay. Any other questions?
Yes, Kelly and the Verity, whether we keep going on Odom is pretty much up to you. There been any movement on that one?
No,
Okay.
I'll still try him before the 16th because I think that's when she's on next, right?
Yeah.
Okay. All right, guys. Thank you.
Thank you.
Okay, and Madam Clerk,
Yes,
the
sir.
other one we had on the docket was Michael Cheney, XZ0708700 mitigation. He does not appear, so we're not going to take any action.
Okay,
Okay, that's it.
that's it.
Okay, thanks so much.
You bet.
Bye.
Bye-bye.